My name is Shambhavi Shivani. I'm a lecturer and Assistant Dean of Career Services. I'm also joined by my colleague, Professor Ashwati Nair Suresh, for the session. On behalf of both of us, I welcome all of you once again. It's an honor to welcome our guest speakers for today's session, Advocate Simon Benjamin and Professor Sandeep Suresh, who will be delivering the lecture on the Code of Criminal Procedure 1973. Let me briefly go through the structure for today's lecture. That is, Professor Sandeep Suresh will be speaking for the first 25 minutes on the topic of magistrates' role in investigation, followed by Advocate Benjamin on the topics hierarchy of criminal courts and its powers under the Code of Criminal Procedure 1973, charge framing, statement of accused, judgment writing. Please feel free to drop your questions in the chat box. Professor Ashwati and I will take them up towards the end of the session. Allow me to introduce Professor Sandeep Suresh, Assistant Professor, Assistant Dean Academic Affairs, and Assistant Director, Legal Aid Clinic, who will be taking up the first half of the session. Professor Suresh is a graduate of National Law University, Jodhpur. Post-graduation, he was awarded the Master's Excellence Scholarship to pursue LLM from the Central European University, Budapest, wherein he also won the Research Award for the Best Academic Performance. Before joining JGLS, Professor Sandeep worked as a research and litigation associate at the Center of Law and Policy Research, Bengaluru, on issues related to the right to education, disability rights, and women's rights. He also served as a research consultant at Daksh, Bengaluru, on projects relating to access to justice and judicial administration for a brief period. Professor Sandeep's academic interests revolve around constitutional law, criminal law, equality law, to name a few. He has taught subjects like legal research and the Code of Criminal Procedure 1973. Professor Sandeep would be sharing his insights on the code today in this half of the session with us on the topic magistrates' role in investigation. I now humbly invite Professor to deliver the lecture. Over to you, Professor.
Yes, thank you so much, Shambhavi, for that introduction. And good morning, Simon. And it's my pleasure to sort of be doing this session along with Simon, a very dear colleague who has been guiding me and we've learned from each other, I would say, and I have learned much more than what he has learned from me, I would say, over the last 3 years of teaching criminal procedure together. And yes, so without taking me too much time, because I will first speak about what travels in the Code of Criminal Procedure from the initiation of when a crime happens and what is the first legal proceeding, which is an FIR that is filed by the police, till the end of that police investigation, which results in a charge sheet or a police report, to be general. Now, it's impossible to cover this entire breadth of investigation in one go in a session like this. So that's why I decided to sort of put it forward in a way where we see this entire process majorly from the angle of the judicial magistrates, who are the first instance courts, if we could say, as far as most of the criminal proceedings at the initial stages of a criminal case. Let's start by briefly looking at what is the first step, right? So, as most of you would by now know, because most of you have done your courses on criminal procedure, is that when a crime is reported and when it is informed to the police, they have to look at the nature of the crime and then decide the course of action, right? So it's not that any crime that is reported and the police gets to know, they come and file an FIR. No, that is where we clearly know the law on what is a cognizable offense and what is a non-cognizable offense. Now, there are, on the academic side, there is a lot of discussion about what has been the logic of this distinction, what has been the basis of dividing offenses into these two categories, etc. But that is, that requires another 2 hours on its own. However, from a very practical point of view, to understand what is a cognizable offense and non-cognizable offense, you have to go to that ready referencer which the CRPC itself provides in the form of a schedule, right? So the CRPC, apart from its various provisions, also has a set of two schedules: the first schedule and the second schedule. First schedule being the more significant of the lot, which is in the form of a table wherein it lists out all the offenses or the crimes in the Indian Penal Code. And to that, they mention whether it is considered as a cognizable one or a non-cognizable one, right? So it's a ready referencer over there. You don't need to sort of, look for, you don't need to get into research to identify what crime is uncognizable. Now, once that is clear, if it is a cognizable offense, that is where the CRPC says the police has to file an FIR. Now, if it is a non-cognizable offense, the code says in the form of, let's say, section 155 CRPC, that the police do not have an authority to step into that case officially if it's a non-cognizable case. That doesn't mean that at a point of time in the case, the police will not step into it. They can only if the magistrate grants authority. That is where section 155 becomes important. So if a person has come to the police station saying that, here is this offense, or here is something that I saw or that has happened with me, and if the police identifies it as a non-cognizable crime, it gets referred to the magistrate. They do not take an action, official action upon it. However, if it's a cognizable case, they do file what we call as the first information report based on what they get from the informant, right? Now, once the FIR is filed, right, that's where you will see the magistrate of coming into the position. Now, let's divide the discussion in two ways here, right? Let's first think of a situation that, quite frequently happens in real life, which is that the police at times refuses to file an FIR upon your information. Now, what happens there? Magistrate is one of the authorities that can intervene at that particular stage. This is why I said it's one of the first instances court, as far as all the nascent stages of criminal proceeding is concerned. Now, what the CRPC says directly is that if the SHO of a police station has refused to file an FIR based on your information, your first remedy is before the superior police officer. Okay, you can write to the superior police officer and get the remedy done. Now, that being a remedy within the police hierarchy itself, many people, first of all, they don't know about it, or many people do, hesitate to do that because of the lack of confidence, maybe in the police hierarchy. So the next step that they go to is under section 156(3), 156 subsection 3, wherein they approach the magistrate with an application to direct the police to file an FIR. Right? In that, you will briefly describe what is that crime that has happened with you, or what is that information that you had shared with the police, and the reasons why the police, told you that they have refused to file the FIR, and pray before the magistrate that please direct the police to file the FIR in such a case. Now, that is one of the first tasks that in most cases the magistrates end up taking, which is to direct the police to file an FIR by passing an order under 156(3). Now, one thing to be noted there is, now, of course, right, if there is an order from the magistrate, you would ideally believe that, okay, then the police should take action upon it forthwith. However, there have been again instances where that has not happened, and magistrates, while passing orders, in some places have, given another instruction in that order to sort of say that, within the next 10 days, you need to file a compliance report. The police needs to file a compliance report stating whether you have actually filed the FIR and have you taken up investigation in that matter. So magistrates in that sense have, how do I say, a supervisory role over there at that stage to see if the police is adequately complying with its duty under section 154. Now, why is it important? Because 154 says it's a mandatory duty on the police, right? However, so this is one thing that magistrates do. Now, the Supreme Court in certain cases, especially in the last decade that I know of, has identified a problem here that because of easy route through magistrates, many of them end up applying this, whenever they cannot get an FIR filed, they end up applying this application, giving this application before the magistrate. And in certain cases, they've realized that those applications do not contain any substantive allegations about a crime. And magistrates, without applying their mind, pass an order to the police saying, you file the FIR. There have been several such instances where the court has found about this. And the court in certain cases, one representative case that I could mention for your sake is Priyanka Srivastava versus State of Uttar Pradesh. It's a 2015 Supreme Court decision in which the court said, if you have to file an application under 156(3) before the magistrate, you better file a affidavit along with it, right? So you can't just randomly, in 2 pages, put something on paper and give it to the magistrate, because then your liability is not there. As all of you would know, right? With an affidavit, which is, signed and which is on an oath, has certain potential legal consequences if the authorities come to later find that you have lied on that affidavit or you have misrepresented the facts to the court on that affidavit, then there can be legal consequences against you. So hopefully, to act as a deterrent, that is why the court said so. So certain such limitations and certain such practical issues are there with respect to this power of the magistrate at this very early stage of investigation. I could say investigation has not yet started at this stage of filing such an application, but nonetheless the nascent stages of a criminal case. From there, let's now look at, okay, what happens if the police automatically files an FIR and starts investigating, right? Now there also, the magistrate comes in at a particular stage. Now, it's not always that the police will, refuse to file the FIR, and then that's a problem. That's one type of a scenario. Another type of a scenario is where the police will file the FIR, but after that they will not take any action upon it, right? So the investigation is not moving, nothing is happening in that case, and the informants or the victims are clueless about what is the progress, right? There also the CRPC statutorily devises a magisterial supervision over there on the police, right? For instance, you have to take a look at section 157 till about section 159. These provisions in that bracket, read together, gives you a sense that, police cannot randomly stop a particular investigation into a case in the initial stages. For example, section 157 categorically says to the police that if upon filing an FIR, let's say, the police comes to the knowledge that, okay, this is a random frivolous case, there is nothing substantive there, there's nothing, significant there to be considered as a cognizable crime, so I'm stopping, right? In such a situation, they have to file a report before the magistrate, giving reasons of that. This will then allow the magistrate to, of course, apply their mind and determine whether it's a right step by the police to sort of, give a pause to that particular investigation or not. Section 159 tells the magistrate that magistrate can also, if the magistrate is of a different opinion than the police, that, this is a case where you should have legitimately gone ahead with the investigation, especially at the initial stages, where delay in time can be, can prove to be, very adversarial, quite adversarial for the later aspects of this case, right? Can prejudice the case's, positive side. Loss of evidence can happen, loss of forensics can happen. So delay of any nature at that stage, the magistrates have to be mindful of that, and they have to utilize section 159, which I believe is not a provision that is largely discussed, at length in most places. So even what you realize is the magistrate's larger power, again, you have to understand, it's not like magistrates can interfere with each and every step of the investigation. That's not what is envisaged. Magistrate can intervene only when they realize that the police has, not complied with the duty in relation to the facts of the case. One is if they have not filed the FIR, I told you 156(3). Now, even if they have filed an FIR, but they have then just sat on their chair and done nothing, there also, magistrate can under 159 keep a check. So what you see here is a a very significant checks and balances at play, right? Checks and balances being a system or being a principle that you usually discuss in constitutional law. In practice, this is one of the places where you can see that happen. Now, from there, if you go down to the idea of arrest, right? Let's think in that terms. One of the first steps or the first objectives of the police when they get into an investigation is to apprehend the offender. Now, how do you apprehend the offender? By the official process of arrest. When you arrest somebody, there are, of course, different procedures and different rights given to the arrested individuals. Section 41 to about 60 deals with the primary rights and rights of the arrested, potentially arrested people, and as well as the duties of the police officer. Now, where does the magistrate come in here, right? Now, of course, at the stage of arresting, it is, of course, the police's complete domain there, right? Because magistrate is not on the ground. We do not have an inquisitorial system where the magistrate comes off the court and then, is going with the police always for investigation. No. So only when the person is arrested and brought before the court, that is where the court can again come in with a supervisory or a check on the police to determine whether it was a valid arrest or not. There have been several instances where the courts, the Supreme Court especially, has passed judgments after judgments, if I could say, detailing out the guidelines which the magistrates have to follow when a person is brought arrested before them, right? Especially, there is a clear distinction that the code makes between arrests in cases which have a punishment of less than 7 years and arrest in cases which have a punishment of more than 7 years. The distinction between serious and non-serious cases, Section 41 talks about it. Now, there are different considerations under both these provisions, which is why, for example, a case like Arnesh Kumar versus State of Bihar, if you look at it, the court has categorically clarified and held in that judgment that when an arrest happens in a case for which the punishment is less than 7 years, the magistrate has to pay a more closer attention to the details of the case to determine whether it is a valid arrest or not. Therefore, they have to look at all the processes. Did the police, get the arrest memo prepared while the arrest was happening? Was it properly signed? Were the witnesses there? Was the family members of the arrested person informed about the arrest? Whether medical examination was done. If yes, where is the medical examination report? Peruse through the report. See if there is any discrepancy over there. See if the 24-hour rule has been fulfilled or not, right? For example, I mean, all of you know the constitutional rule of 24 hours post-arrest. Very significant period, right? Now, if that has been complied, that has to be checked. If not, the police has to be, caught there, red-handed. If the arrest is not found valid based on all these assessments, and of course the larger necessity in terms of the facts of the case, then of course the magistrate has the duty to sort of release that person on bail. Or if not, there is another mechanism of remand which we will now cover, which the magistrate goes to. At this stage, very important, again, there are multiple cases starting from the very old Zainara Khatun judgment to all the new cases that have come based on that. Magistrates also have a very predominant duty at this stage to sort of ensure that the person brought before him or her has the legal representation at that particular stage, right? We all know that the right to free legal aid, the right to have a lawyer, etc. These are all, fundamental rights, as per the several judgments. But whether it is happening on the ground, who's the only person who can ensure it? The magistrate. Because prima facie, you can't expect the police to sort of do that, right? Police, you cannot have a bona fide expectation that, okay, they will appoint or they will get the district legal services authority to appoint a lawyer for each of the accused that they have brought in. That's not happening. So the only person who can do it is the magistrate. Very significant role again. Now, I told you, if the arrest is found invalid, you can send that person to on bail, right? However, there is another process which is called remand, where the magistrate does not send that person on, bail, but depending on the situation, depending on the assessment, and depending on the judicial application of mine, the magistrate can decide two types of remand. Remand is that process where you are sending that person who's arrested into further custody, right? It's only the 24 hours, the first 24 hours of arrest that the police has, how do I say, absolute discretion about the custody of that individual. After the 24 hours, the custody of that arrested person can only be authorized by the magistrates. Very significant. Now, they can do it in two ways. Either they can send you to police custody or judicial custody. There are certain rules that are specifically designed for that purpose. Now, what is police custody, judicial custody, right? Very significant to be, underlined, even though I'm expecting most of you would know about it. Like, one of my lawyer friends was sharing with me an incident that he had heard from a judicial academy, a state judicial academy, where a new entrant had asked whether judicial custody means that the person is kept in the court itself, and police custody means the person is sent to the police station. Now, that's not the, the literal meaning that we need to have. Police custody is that situation where you grant the custody of that person to the police, and the police keeps that custody at their police lockups or police headquarters, or wherever the questioning is happening, where the interrogation is happening, or even take that person away with them for the investigation to the crime scene, reconstruction of crime scene, etc. Judicial custody, on the other hand, is not keeping the person in the court itself or within the judicial officer's presence, but sending that person to the prison, to the jails, which is separate from police lockups that you see in police stations. The implication is that when you send the person to judicial custody in the jail, police do not have direct access to that person. If the police needs to have access to that person, then the magistrate's approval should be there. There are certain procedural safeguards for that. So, as you can imagine from that description, police custody is what the police will prefer always in certain cases, right? Now, the magistrates have a big role to play. They are not mere rubber stamps at this stage to sort of grant police custody as per the police's request. They have to look at this incident. They have to look at the significance of this case. Now, the considerations at this case is always not probably about the seriousness of the offense. It's not always solely that, right? It's about the factual scenario that, is there a need for interrogation? Are there evidences still at play in the society or in the community where if this person is left out, those evidences will be tampered with or destroyed, right? These are the considerations. Or for that matter, if this person is released on bail, will it cause, will they abscond, etc.? These are the similar factors that are considered as far as police custody, judicial custody is concerned. But most important in that situation being, what is the requirement of the police to have this chap in their custody live with the purposes of the investigation? Now, typically looking at the initial stage of any crime, where police still requires more information about that case, right? Of course, they would want police custody, and that is quite sensible, right? So in that situation, you will see the magistrates giving at least the first few days for police custody rather than judicial custody. Now, that's very important to understand, right? Now, when we say that, okay, initial days here, it is understandable that the police will need this person to be interrogated, so police custody makes more sense. But again, the law has been devised in a manner to put magistrate under more responsibility to not grant the police blanket police custody for, let's say, even 1 week or 2 weeks. Which is why Section 167 of the CRPC uses terms like, from time to time, the custody has to be authorized, right? So what does it mean, time to time? Which means there has to be regular intervals of magisterial check on the remand process. Which is why you will end up seeing, look at all the cases that you will see around when you go for internships or wherever. You will see the magistrates passing remand orders wherein they are granting police custody for 2 days. Then again, after 2 days, the police will bring back the person before the magistrate. Then again, the magistrate will reassess the scenario, will determine if further police custody is necessary. If they find it to be necessary, then again they will give another 2 days. Then again they will come back. Then if the magistrate believes that, okay, now most parts of investigation is over, most parts of interrogation with respect to this chap is over. Now the whatever investigation that is left by the police is independent of his presence. In that situation, they will send, the magistrate should send that person to judicial custody, right? Now, from there, if you look at into it, the custody, section 167 talks about the larger period of custody that a person can be kept under, even by a magistrate. Okay? Now, how is that calculated or how is that determined? Now, this is where the CRPC comes and gives a nudge to the police that, an indirect nudge to the police that, and also duty to the magistrate, that from the first day of remand by the magistrate, within 60 days, or in certain other cases, within 90 days, the investigation ought to be completed. How do you complete the investigation? By filing what we call as the police report. Now, what is the logic there? The logic there is to sort of tell us that for unreasonably long periods of time, one person cannot be kept in custody because of the delay caused by the police for their own, lackadaisical approach or anything. Which is why the law comes and says in 167 that in cases or investigation of offenses where the punishment is less than 10 years, investigation ought to be completed in 60 days. So any case which has a punishment of more than 10 years and above, which is your murder and other grievous offenses, there is an automatic presumption that you will need some more time to complete the investigation. So another month is given. So within 90 days, you have to file the police report. Now, what is the consequence? Consequence is that if on the 60th day, or depending on the case, or on the 90th day, if the police doesn't file the charge sheet or the police report, then this person is entitled to be released immediately without any further questions being asked, which is what we call as default bail or statutory bail, right? That's seen from the angle of rights of the individual to avoid unreasonable detention due to delays caused by the administration, right? Now, here the magistrate's duty is to sort of keep a check on whether the police actually files a charge sheet on the 60th day, right? If not, the magistrate has to then immediately release this person on default bail, even if, trust me, even if no application is as such filed by the person, because you cannot expect that person to know that, okay, my 90 days are up and the police is still not filed, which is where we need, of course, good lawyers, right? That's where we need legal aid. If we do not have that sufficient or quality legal aid, then this right also goes underwater, which is where magistrates also have to assess the records and see the development of the case. And if the charge sheet is not filed on that day, then automatically grant the bail, right? Now, that's very significant. There are some tricks that the police does, which again, the magistrate ought to be mindful about at this stage. Now, it's quite impossible in certain cases to finish an investigation in 60 days, okay, or an investigation in 90 days. But in most cases, in certain cases, it's possible. But again, we do have a lot of administrative issues with respect to that. I'm not getting into that. Now, what the police will do is, they have this power under section 173(8), a power to do what? A power to do what we call as further investigation. Police has the power to do what we call as further investigation after filing the first charge. They can thereafter keep continuing their investigation to find more evidences or to find more information. If they find more information, then they can file that information before the court by a supplementary charge sheet on top of the initially filed charge sheet. Now, what do they do in such scenarios with respect to the 60-90 day period? They will file a half-baked charge sheet on the 60th day. Why? To complete that formality. Because the moment the police files a charge sheet on the 60th or on the 90th day, as the case may be, then my right to be released on default bail under section 167 gets extinguished. Because that right is dependent upon whether the police files the charge sheet or not. That's the single question that is asked. So to curtail my rights over there and to complete that formality for the sake of it, the police will file a half-baked charge sheet. Doesn't matter for them because they know that they have the power to continue their investigation and file a proper charge sheet later as well. So magistrates at the stage have to be very cautious about it. Again, they cannot be rubber stamps. Okay, police has filed a charge sheet. I will seal it off. Bye. Your bail is done. No, they have to peruse through the charge sheet at least briefly to understand whether it is a tactic or is it a genuine charge sheet that is filed after a thorough investigation. If they find it's a half-baked charge sheet, yes, they do have the power to send it back. They do have the power to tell the police that you please continue the investigation and resubmit a new report which is more comprehensive. There are few judgments that sort of indicate towards that end, right? So again, the magistrate being not a rubber stamp, very, very significant, as you can see at every stage, right? Right from the stage of FIR to the stage of arrest to the end stage of filing the charge sheet, the magisterial supervision is very significant. Beyond all of this, there are certain other places as well where the magistrates, employs his or her supervisory power, which is magistrate usually is the person or is the authority that authorizes search warrants for the police officers. Magistrate is the authority who issues arrest warrants. If arrest needs to be done through a warrant to the police officer, it is the magistrate who issues. It is the magistrate who decides whether it should be a bailable warrant or a non-bailable warrant. So multiple stages of investigation, as you know, right? Search and arrest are all parts of the investigation stage. The magistrate has a role to play. Of course, they cannot, dictate the police that, okay, you do investigation like this. No, don't go to that person, you go here. That and all they can't do. They can't be invasive in that sense. But yes, to keep a check on the police, to keep them in line with the CRPC's processes, and processes which are not just merely processes, but they are also certain processes which are also equal to substantive rights. To keep a check on that and ensuring that it is fully complied with, magistrate has these superior supervisory powers all throughout the stage of investigation. So yes, with that, I will conclude. I know I've taken a lot more time and crept into Simon's time period, but I will stop here and probably we'll address other concerns during the Q&A session. Thank you so much.
Thank you so much, Professor, for explaining to us the role and powers of magistrate and the investigation and the important judgment that you discussed. I'm sure the students as well as we have benefited from it. Now I invite my colleague, Ms. Ashwati, to take over the session. Over to you, Ashwati.
Hi, I hope I'm audible. All right. Good afternoon, everybody. Good afternoon to the guest speakers who have very politely and very humbly spared their time this afternoon in spite of having a very busy schedule to sort of brief our students about how they can go about this subject. I have the pleasure to introduce Mr. Simon Benjamin, who has over 14 years of experience as an advocate specializing in criminal litigation. He has handled several cases before the Supreme Court of India, the Delhi High Court, and the trial courts across different states and different cities in India. After graduating from Symbiosis Law School from the first batch in 2007, Mr. Benjamin joined the chambers of Mr. Sidharth Luthra, Senior Advocate and former Additional Solicitor General of India. And thereafter, the chambers of Mr. Siddharth Aggarwal, designated Senior Advocate. So in addition to his practice, Mr. Benjamin has extended his passion for the subject and has been teaching at the Jindal Global Law School as an adjunct faculty for the last 3 years, since 2018. Mr. Benjamin's contribution towards pro bono work for the rights of women was recognized by the Navoothan Charitable Foundation, where he was felicitated with an award by Justice Ranjana Desai, former Supreme Court judge in 2016. He was also awarded a certificate of recognition for providing legal support to religious minorities by Alliance Defending Freedom India. Over to you. Am I audible? Yeah. Over to you, Mr. Benjamin. We hope the students make the best of this opportunity to learn from such an expert, and we are so grateful to have you today in our session today this afternoon.
Thank you so much, Ashwati. Thank you, Sandeep, for that insightful lecture. In fact, after hearing you, I had almost forgotten that I had to speak. So it was actually quite enjoyable in terms of not only the academic inputs that you were sharing with the students and also us, but also the little bit of anecdotes that were being used to kind of illustrate those provisions that you were talking about. So it was actually quite enjoyable. I'm going to be taking the next few minutes to try and tell the students about what we are going to be discussing, mostly about the trial system. So hello to everyone. Hello, friends. The topic I'm going to be discussing are here in front of you: hierarchy of criminal courts and the powers of the courts. So we're going to be talking about this only briefly to understand the position of these courts when they are dealing with those trials in different cases. We'll also touch upon the framing of charge. It's an important aspect as far as judicial exams are concerned. And we will also discuss judgment writing, which is another topic that's important as far as judicial examinations are concerned. I have included statement of accused in this portion, in this segment, because I feel that it has an impact when you're doing judgment writing. You cannot have judgment writing without knowing fully well about statement of accused, though it's not a category on which I have found the examinations are based or they test students on this. But we'll go ahead with our discussion then for today. So coming straight to the hierarchy of criminal courts, I hope the slides are visible.
Yes, sir.
So we've seen this is a structure most of you would be familiar with.
Can you probably go to the presenter view so it makes it bigger? It's, I think, down there in the bottom bit, the bottom tab. Yeah. That one.
Okay. So we're all familiar with this structure. The structure essentially will tell you that the provisions contained in the CRPC, especially pertaining to trials, will affect only the district court where all these trial courts are situated. We'll see what are those different trial courts. The appellate jurisdiction would come to the High Court after it's reached a point in the Court of Sessions where they would take it to the next logical conclusion, and so that which is why there would be appeals filed both from convictions and acquittals to the High Court. You also have the original extraordinary jurisdiction which High Courts have under Section 482. That is not an appellate jurisdiction, but something where the High Court feels that it needs to interfere in a proceeding, whether it's investigation or a trial, to bring in some sort of justice for a party that's seeking relief. There's also revisional jurisdiction, which is another aspect of appellate jurisdiction. And of course, we have the writ jurisdiction, which the High Court exercises as a writ court in criminal cases. The Supreme Court, of course, also has its own powers in dealing with criminal cases, whether it's in its appellate jurisdiction or even where special appeals are filed seeking leave of the court, and also its writ jurisdiction under Article 32. So we'll see the district court essentially today because we're looking at trials. So at the top of the chain, we have the Sessions Court, which also deals with a specific kind of trial that it is originally supposed to look at, apart from the appellate jurisdiction that it has over the magistrate courts. And these are the other magistrate courts which are placed before you at the bottom of the structure. But essentially at the top of this, we have the Chief Metropolitan Magistrate in metropolitan areas. An equivalent power is there in a non-metropolitan area as a Chief Judicial Magistrate. We also have the Judicial Magistrates first class and Judicial Magistrates second class in non-metropolitan areas, and metropolitan areas you only have metropolitan magistrates. So what is this metropolitan distinction of metropolitan in these different courts? It's nothing but something that's based on population and municipality. So when, in fact, I can give you an example of Delhi, which is essentially where I mostly practice. So in 1973, when we had the new CRPC, back then the new CRPC, when it came in into force, then on 28th March 1974, Delhi was declared as a metropolitan area. Before that, we would have these judicial magistrates second class and judicial magistrates first class operating in these courts in Delhi. So since then, because it got declared as a metropolitan area, so therefore there was only metropolitan magistrates who were operating in Delhi, and which is why we have metropolitan magistrates and chief metropolitan magistrates um, in these courts. There's also the assistant chief metropolitan magistrates or additional chief metropolitan magistrates, which is another category of judges, magistrates, which are between the CMM and the MMs. That is essentially to assist the chief metropolitan magistrate with their jurisdiction. It's mostly an administrative jurisdiction that's been created to provide for assistance where there are more number of police stations, because there's only this much a chief metropolitan magistrate or a chief judicial magistrate would be able to do because of the administrative duties that they also have apart from the judicial responsibility. Now we look at the most essential thing, which I consider actually before I get into the aspect of trials, I need to understand the power of the court. What can a court do when I'm in front of a court, when I'm in front of a magistrate's court or in front of a sessions court? I need to understand what is this court's jurisdiction in terms of what is the maximum damage it can do. As a defense counsel, I want to understand what kind of trials it deals with, what is the maximum punishment it can impose. So here you have that. We'll first start with the powers of the sessions court. Now in sessions court, we have these different categories: the session judge, additional session judge, and assistant session judge. So if you look at session judge and the additional session judge, they are practically having the same kind of power where they can impose any punishment except a death sentence. Why? Because actually even a death sentence can be passed, but it has to be confirmed by the High Court. So that's something which the High Court will deal with as a reference when it's also hearing the appeal from that conviction of the accused. So that sentence reference and the appeal from the accused are going to be heard simultaneously by the High Court before it confirms the death penalty. The assistant sessions judge has a limited role in terms of the punishment that it can impose. We can see here that it can only impose punishments which are not exceeding 10 years. So therefore, anything beyond 10 years is not within the purview of the assistant session judge. Clearly, the life imprisonment and death penalty are also ruled out. Now we come to the powers of the magistrates court. So we can see here that the chief judicial magistrate or the chief metropolitan magistrate, who are essentially having the same power in a metropolitan, non-metropolitan area, they can impose any sentence except those which are exceeding 7 years. So essentially they cannot also impose a sentence that is of life imprisonment or a death penalty. The judicial magistrate first class will be able to impose a punishment which is not exceeding 3 years. And also there's a restriction on the fine, the amount of fine they can impose. So that cannot again exceed more than 10,000 rupees. While the judicial magistrate second class can only deal with cases where the punishment is prescribed for up to 1 year. So it cannot exceed that 1 year sentence. And even the fine has a restriction of 5,000 rupees. So which is why we may find that even in a lot of non-metropolitan areas, you will not come across judicial magistrate second class, because there may not be a necessity for having a judge who's going to be dealing with those cases, because most of these punishments may exceed 1 year. And wherever it is less than a year, if there is a need for a judicial magistrate second class, then they would have a very a lesser vacancy for the same. We'll now look at different forms of trials. So essentially, there are these four kinds of trials. Some of you who are familiar with CRPC would have seen this before. It is just for an easier understanding. You can see that these are the provisions which deal with the different kinds of trials: summary, summons, warrant, and sessions. 3 out of these 4 trials are dealt by the Court of Magistrates, while one of those trials is kept for the Court of Sessions. Now, even the Sessions trial actually originally begins at the Court of Magistrate. So there are certain provisions which we will be seeing which are common to all of these trials, which is why we can see even in a Sessions trial, the commencement of that trial is before the Court of Magistrate, not in the Sessions Court. Of course, there are these special courts that we also hear about. The special judges are sometimes these additional session judges who are being designated as a special court, but they're operating as a magistrate. The powers that they use, we can look at the example of the Prevention of Corruption Act. So when those cases under the Prevention of Corruption Act are dealt by a special court, by a special judge, then that special court is using the powers of a magistrate, which is why, as Professor Sandeep Suresh had explained us, when on completion of investigation, when a police report is filed under Section 173, that report, which is normally to be filed before the court of a magistrate, for the magistrate court to take cognizance and issue summons, would be filed before a session judge who's now operating as a special judge, since you're looking at that person as a magistrate. Another thing I wanted to also point out is that we know that since Professor Sandeep Suresh spoke about investigation, that is one aspect of cases which commence from the registration of an FIR, Section 154. But we also have complaint case processes which are under Section 200. So both these category of cases are covered in all these 4 category of trials. So which means that actually you are looking at 8 forms of trial under the CRPC. So every category, whether it's summary, summons, warrant, or sessions, has both an FIR process and a process for the complaint cases. So these are some of the common provisions we're looking at. Section 190, some of you again would be familiar with these, but these are important provisions. I thought we should just touch upon them before we look into the aspect of trials. So 190 again is unique to the magistrate because this is the provision which a magistrate uses to try and understand what are the offenses that have been committed, which is why the cognizance is of the offenses and never of the accused. And which is why even at a later point when an accused has to be summoned, an additional accused has to be summoned, the court doesn't have to take cognizance again. In fact, even if there are provisions which are being dropped, the offenses are being dropped or new offenses are being added, the court doesn't have to take cognizance again. It's only once in every trial, it's only once that this cognizance will be taken by the Court of Magistrate. Another important provision which you would be familiar with is Section 207. This is again in relation to those cases which start from the FIR process, what Professor Sandeep Suresh spoke about. So this is an important provision because this deals with providing the accused with all of the material that the investigating agency has collected. The entire process that was explained to you so well by Professor Suresh, where he said how the police go about collecting that material by search and seizure or using of Section 91. All of that material is now provided to the accused persons at this stage where Section 207 is applied. The accused persons have to be provided with all the documents and all the witness statements which have been recorded under Section 161. These are statements which are recorded by the police. We have a similar process, in fact, even in the US, which I always look at as a great example for less number of litigations, because there, where we see that this process is used of providing, the defense is provided with all the material by the prosecuting agency. It's called the DA office, the district attorney office, which provides them all this material. And then there is a discussion as to understand, looking at this material, does the accused want to face a trial, or do they want to admit their commission of crime and plea for a lesser sentence? And which is why there is a large number of cases which end at that stage as far as that jurisdiction is concerned. And we see very little cases that go into trial because they have a jury system, and those punishments, some of those punishments can be really lengthy for an accused person. So it acts as a good stage for cases to be brought to an end. In India, we have a similar process under the common law system that we had borrowed. So we now have 207, which is also used to give the accused a fair idea as to what the prosecution's case is going to be. And if the record is voluminous, then the accused is definitely given an opportunity to access it, even if they're not given a copy of the same. 208 is a similar process which is used for mostly largely complaint case, and it's also utilized mostly in the sessions trial, but it's a similar process as akin to 207. And lastly, we look at 209. This is a provision which deals with committal of cases. So like I was saying earlier, that all of those cases which are triable by the Court of Sessions and are coming under the category of sessions trial, even they would have to commence in the magistrate's court, because the magistrate is the one who is accepting the reports under which are filed under 173(2), and then later, even if there's any supplementary charge sheet that's filed, would be filed before that same magistrate's court. These are then committed to the sessions court under 209 after the magistrate has taken cognizance and summoned accused persons. We'll now come to the most important, one of the most important aspects for today's lecture, which I want to cover, that is framing of notice or charge. Why is it called framing of notice? Is because that's the nomenclature that's used by for the summons trial. So when we have summons trial, there is a framing of this notice, and when we see the same process for the warrants trial or the sessions trial, we see the nomenclature that's used is charge, framing of charge. So it's a process that's very similar to something we also see in CPC, where a civil court is looking to crystallize issues. Two parties come forward, one of them wants to litigate, the other one has come forward to defend themselves. And here we find that when these parties have come forward and they've given their version of facts to the court in form of written pleadings, the court takes that material and crystallizes the issue. So it will distinguish those facts which are admitted, or they are an admitted position, and leave those aside, and then take those which are disputed facts relevant for the court to grant some relief which the party is seeking, and frame certain issues on which now evidence will have to be led. In CRPC, this process is something similar, but it's in the context of the offenses that have been committed. It's an important stage. Why? Because I can say this from a practitioner's point of view, that the court is going to look at the ingredients for the offense. So let's go back a little. This might overlap with what Professor Sandeep Suresh has already explained to you, but just to give it more context, if you remember when he mentioned about someone going and making a complaint, a layperson goes and makes a complaint, is not familiar with the ingredients of the offenses. They are not familiar with the definition of offenses. What they know is that they have been wronged, and they are familiar with the facts that are in relation to the wrong that has been committed. So when a layperson goes into the police station and narrates what has happened, and it's reduced into writing, it is for that police officer to understand as to what facts make out which offense. So for this, then they would look at the IPC or look at any special statute under which those offenses are contained to see which ingredients of offenses are made out. There are these definition provisions which may not be the punishing section. So the specific provision may not contain the exact punishment for that offense, but it will describe exactly what that offense is. So looking at those ingredients, they will find that commonality with the facts that have been narrated by the victim or the informant, and then provide sections to those corresponding facts in the FIR. And that's the job of the police officer and not the complainant. The complainant doesn't have to identify the offenses. They simply need to narrate the facts of what has happened with them. Now, when we come to the stage of charge, why did I go into this? Was because it's relevant here. The court has to now look at those very facts which have been provided by this victim or informant. And those bare facts will then have to be looked in the context of these ingredients of the offenses that have been given under the CRPC or any other, sorry, not under the CRPC, under the IPC, I beg your pardon, or any other special statute, to understand what offenses have been actually committed in this case. So this is not an exercise that the police officer has undertaken for writing the FIR, or even when they are submitting the charge sheet. And which is why since this is a judicial exercise, there could be a lot of errors that can be rectified at this stage. So a judicial officer at that time, the magistrate who's framing this charge, framing this notice, or the sessions court, which is hearing arguments in charge and framing this charge, doesn't necessarily have to agree with what's done in the FIR or what's done in the charge sheet. It can actually find that there may be material to see that there is actually another offense that has been committed and add that offense as well. Or it can actually drop certain offenses because it may feel that these offenses are not made out, the ingredients are not made out. It can also do something which I find more and more common these days. Last few years that I've been practicing, I've been seeing that courts are increasingly looking to frame alternate charges. So, what are these alternate charges? They don't want to waste precious judicial time, which is why when they're looking to frame a charge, they also look at the fact that sometimes these ingredients could make another offense as well, make out another offense, and they frame an alternate charge along with that so that it's easier for the court to come to a determination. If a person is being acquitted of the larger offense, then at least they may be convicted for the lesser offense because of the fact that the facts may be similar and they really can't predict what will get proven in the trial. When the witnesses come and speak and they're cross-examined, when documents are exhibited, when materials are exhibited, they really have no understanding at that time what would be then proven better, whether it will be the initial charge or the alternate charge. And which is why, to save the time of the court, of course, the court also has, why was this process not being done earlier? Someone may ask. It was because the court also has the power to alter the charge at any stage. Right before the judgment, it can alter the charge also. So there is no requirement for the court. It's not a process that can't be revisited. But of course, the court wants to protect everyone's interest, because if the court does exercise that right of altering the charge at the final stages of the trial, it might prejudice the accused person. Sometimes the accused person may also want to recall some witnesses for further cross-examination. So it may further lengthen the trial, and therefore, to save precious judicial time, the courts have now started doing this more often, this process of framing an alternate charge. So we find that 251 of the CRPC, which deals with this process of framing of this charge, which is called framing of notice, because it's not a formal process, considering it's a summons trial. It's for offenses which are assumed to be non-serious. Of course, this is just a very plain understanding of it, because the the difference between a summons and a warrants trial is merely prescribed by virtue of the punishment. So anything which is punishable beyond 2 years is a warrants trial, and anything lesser than that would be a summons trial. So with that understanding, we know that if the offense is punishable by less than 2 years and it's a summons trial, then it's not as serious as one which is considered as a warrants trial. But there's no other explanation provided under the CRPC to show why certain offenses are being categorized as summons, warrants, or sessions trials. In fact, there's no distinction between a warrants and a sessions trial. Only those offenses which are triable by sessions court are sessions trial. So for this, the only document that we have for reference is our first schedule. So the first schedule provides for this distinction. I mean, students of law, lawyers, we all just refer to this schedule to understand which offenses are triable by which courts, because there is no further explanation provided for this differentiation between offenses. And as far as sessions trial is concerned, in fact, they're also part of this larger set of warrants trial. So maybe you can say that all of these offenses are maybe warrants trial because they are beyond 2 years. So including death penalty and life imprisonment would be considered as a warrants trial. A part of it is tried by the magistrate courts, and some of them are tried by the sessions court. So now we look at the types of cases. We've already dealt with this aspect, but just to understand where these police reports are filed, we have a separate category of trial prescribed for warrants cases which are instituted on FIRs, and the process for the charge is under section 240, where you have complaint cases which are warrants triable. The process is 246. But so here, the interesting part is, if you've seen these processes, if some of you who are familiar, we would understand that a complaint warrants trial is one of the most unique forms of trial. It doesn't have any commonality with any of the other forms of trial that is there in the CRPC. And it's one of the most toughest trials also, because it makes the bar that much more tougher for the complainant to prove its case. Why? Because there are three stages for them to lead evidence. There's a pre-summoning at the stage of 200 when they come forward to the court for the very first time. They also have to lead evidence at the stage of charge. There's a pre-charge evidence where the accused person gets an opportunity to cross-examine, and because the accused is already present before the court at that stage, and finally at the stage of complainant evidence. So there are three stages of this evidence being led by the complainant in a complaint warrants case, while in a complaint summons case, you'd only have two such stages where there is pre-summoning evidence before the accused comes in and is summoned, and the later stage is when the complainant wants to lead complainant evidence. So the distinction here, I feel, is that again, this is not explained in the CRPC, but it is understandable that warrants trial are more serious offenses because of purely looking at the punishment that's been prescribed, and which is why the legislature wants to ensure that if the police has investigated a case under the FIR route and filed a police report, and thereafter there is a trial being conducted, then there is an independent agency that has already looked into that material, and it's considered to be something that's gone through with the process of the trial under that understanding. But when it's a complainant who's doing this on his or her own, then there has to be a higher degree of testing the contents of that allegation, just to understand that somebody is not being harassed in court. There is a genuineness to that particular complaint, and ultimately, if a person gets convicted in a complaint warrants trial, then there is an understanding that the law did take care of the rights of the accused in that sense, to protect by bringing in these different stages of checking whether the complainant's version is consistent, right from the pre-summoning stage to the pre-charge stage, and finally at the stage when the evidence is finally being led. We also see that the warrants cases which are being triable by the Sessions Court, the stage for charge is under 228. There is no such distinction like we have for warrants trial, for Sessions trial. In that category, all the trials are subjected to the same type of trial, whether it's a complaint case or a FIR case. Now we'll see what a framing of charge would be. So here we find that this is a question that the court will frame after it comes to the conclusion that the person cannot be discharged. So what is the stage of discharge? It is only something that's available for these severe trials. That's the warrants trial, whether it's a warrants trial before a court on the basis of a police report, or on the complaint case basis, or a Sessions trial. In these category of trials, there is a provision for discharge, which means that the accused can make out a case before the court that there is no need for them to be sent for trial, and which is why they would be then discharged at that case. It's not the same as being acquitted, because if a person is discharged, there is a possibility that if there are multiple accused persons and one accused person is discharged while the others are charged and they plead not guilty and the court proceeds with their trial, at a subsequent stage, if there's additional material, nothing prevents the court from looking at that person who has been discharged to bring back that person. So a discharge is not exactly a very safe place for an accused person, but it's bringing an end to the person's misery as far as the trial is concerned, because of the fact that they are not going to be facing that litigation any longer. Of course, an acquittal is a complete end of that person's trial, because once a person has been acquitted, they cannot be tried again for the same offenses, because then the constitutional rights kick in and there's the whole protection of double jeopardy. So here we find that this is one important stage. A lot of accused persons who may be facing litigation, criminal litigation, and if they are facing a case which is a warrants trial or a Sessions trial case, they will definitely look at this position as a very favorable position for getting themselves out of the litigation by making out a case. So here they cannot produce facts of their own. They have to rely on the material that's already been collected by the investigating agency or presented by the complainant to make out a case on the basis of the record that the court has to show that there is no basis for the court to proceed against them. And only then looking at that. So the test here is the prima facie test. The test at the stage of the FIR was a test of suspicion, grave suspicion. But now we're at the stage of charge or framing of notice. At this stage, it's a prima facie case. The court would look at all material and assume them to be correct, assume them to be true. Then is there a case still made out against the accused person? If it doesn't, if after looking at the material as it is, which has been provided by the investigating agency or the complainant, if it appears that the material is not sufficient to proceed for trial, then the court will be forced to discharge the accused person. In the event the accused person is not discharged, the court is going to look at framing a charge. So there will be an order. There are two aspects to this stage. There will be an order of charge that the court is going to frame, that the court is going to pronounce with, which will have reasons, and it will be a detailed order giving the accused enough information as to why they have not been discharged and why the court wants to proceed against them. And then there will be a question that will be framed. That's called the framing of charge. So these are the two different aspects. So framing of charge will be where the court will frame the specific question using the material, the ingredients of the case, the facts of the case, and the ingredients of the offenses to ask that question based on the role of that individual. That this is what is against, this is the allegation against you. You on such and such date and on this time at this place have committed this offense against this person. Once the person fully understands the charge, then they will have to answer that question whether they plead guilty or they want to claim a trial. And that's essentially what this stage would be. There are some aspects which are important from a judge's point of view when they're framing this charge. It must be in written form. It must be in the language of the court, which is why we find that certain vernacular languages are used by in certain states where that is the language that is prevalent in that particular state. So it has to be in the language of the court. It must be regarding the offenses that the person is being charged for. It must state those offenses very clearly. The section also has to be the punishing section, which has to be put in the charge. It cannot be the definition section that is going to be put in the charge, because of the fact that the definition section is going to be borrowed for the ingredients, to make out the ingredients, but it won't be a case where the definition section is going to be used for the description of, for the offense to be made out. This is an example of what a charge will look like, where it's under one offense. So you can see this is from Schedule 2 of the CRPC. It's something that the students are required to be familiar with, because of the fact that this is also asked in your question paper. When you're approaching this exam, you will find that they will ask you to frame these charges. So you should be familiar with these two forms that I'm sharing. One is for a single offense, one is for multiple offenses. So you need to know the exact wording, verbatim as it is. They may give you certain provisions and ask you to frame a charge as an example. So you should be familiar with this process. So not only should you be having the understanding of what goes behind this framing of charge process, but you should also be in a position to frame the exact charge as is expected. Now we'll come to the stage of 313. I'll not take too much time. I think we're running out of time a little bit. So I'll quickly try and explain to you. This is a beneficial provision. It's not as some courts I have found out the hard way. Think of this as a stage where they want to cross-examine the accused person, take that accused person by surprise. That is not the purpose of this provision. It's a beneficial provision. It has an understanding. If you look at the object and reasons of the CRPC, it will tell you that this is a provision that has been introduced only because it felt that not every accused person will be having the best defense lawyer and would have had an opportunity to cross-examine the prosecution witnesses to the best of their ability. So which is why the accused for the very first time, and this is the only place where the accused is being spoken to and asked questions to explain if they have an explanation. In that stage of charge or framing of notice, the accused is only being told what the court believes that they have done. and then they have to, it's a yes and no situation. They have to either say, yes, I have done it, or no, I have not done it, and I want a trial. That's about it. There is no further explanation that is being asked of the accused, and neither is the court interested in hearing it at that stage. But at this stage, it is important for the accused to take this opportunity to explain every question that is being put by the court. But what is the court? How is the court asking these questions? These are questions based on the material that has already been collected in the form of evidence, which is why this provision doesn't say when it has to be conducted. It can be conducted at any stage. That's what the provision states. But it's actually done in very practically, if you see, it's been done at the stage where the court has already dealt with the prosecution evidence, and now it wants to frame questions based on that prosecution evidence where witnesses have deposed, material has been collected. They want the accused to answer those circumstances. So if a witness has seen the accused commit a crime, they'll ask the accused, what do you have to say about that person who has seen you? Or if something was recovered from the house of the accused, they'll ask the accused, what do you have to say about, that material that was collected from you? So this was amended in 2009, if I'm not mistaken, where the legislature introduced this concept of submitting the answer in the form of a written statement with the help of, so the court will frame these questions with the help of both prosecutor and defense counsels, and permit the accused person to file the responses in the form of a written statement. So this is not on oath, which is why this written statement will not be again with the support of an affidavit. It will just be a simple question answer format that will be submitted by the accused person. Mostly this process of written statement is kept for cases where it's a complaint summons trial, because those are offenses which are including some of these check dishonor cases. You might find that this process is used because they are considered to be non-serious. So we've already seen what the objective of 313 is. I'm just going to skip that quickly. The slides are available with the organizers, so please feel free if any of you want to ask for it. I'm pretty sure they'll be more than happy to share it if you may find it useful. These are some of the points to be considered. Again, I'm going to skip this because I want to move quickly to the part regarding judgments. So now we've come to the second most important aspect of the lecture that I wanted to cover, that was judgment writing. This is again important from the point of view of the examination. It is there's a purpose of this judgment writing which courts have to understand. So after considering all the laws and evidences which have been cited before the court, they come to a conclusion whether a person is guilty or innocent. In fact, this process is very intriguing for me because as a lawyer, I can tell you, I'm a student of mathematics. I enjoy this subject, and I find criminal law a little bit like that. But every time you take the fixed components, you take the sections, all offenses are same, prescribing the same punishment. But what are the variables? The variables are these accused persons who come with their own peculiar facts, and you give them to these courts, which are supposed to be, again, fixed components. All courts are supposed to operate in the same manner. But what comes out at the end is not the same result, because of the fact that judges have a different way of perceiving those facts. And for the same offense, there might be a varied kind of punishment that could come out of these courts. It may not be as drastic as one court is acquitting and the other court is convicting, but where the two courts are convicting, you might find that there might be a difference in the punishment that's meted out, because they may see that, and on similar facts, because of the fact that what has impacted the court much more than the other one. So which is why it's an interesting phenomena. It is always intriguing. There will always be some parties, some defense lawyers will be unhappy, some people will be pleased with the court, but then these are not factors which are controlled by anyone as such. And that's something that is also spoken about, the kind of discretion a court has while imposing, sentencing, etc. So here, obviously, the court is determining the rights. There is a need to develop some sort of, jurisprudence for bringing in this consistency, which the courts have to deal with while passing its judgment and pronouncing its sentence. It also sometimes serves as a precedent when this judgment is upheld by a high court or the Supreme Court in the appellate jurisdiction. So there these become precedent for other courts to follow. There is also an accountability for judicial officers because of the fact that they are dealing with the lives of people, and whenever these judgments are challenged, it is an opportunity for the appellate court to either uphold what the trial court has held and or to set it aside, and which then I feel I do not know this process, but if there is an factor to see how many of those judgments of one particular judicial officer are being upheld or likewise are being set aside, then maybe there has to be some some sort of a consistency with regard to the manner in which that person has to function as a judicial officer. The reasons again are communicated by the court in its judgment. So not only does the court in the judgment deal with the entire process of the trial, but also it tries to bring in the aspect of giving its reasons, which is very important as to why it has decided to do one thing over the other, why it has decided to acquit the accused person or convict the accused person. The grounds are important for the court to provide, so that there is enough opportunity for the person, the accused person or the victim, to understand whether they want to appeal against this judgment. It's not necessary that sometimes I have seen a good judgment. If it's not in favor of a party, they may choose not to appeal because they understand fully well that there is really no point in appealing against this judgment. So it's not necessary that it's a automatic robotic instinctive action that a person gets a negative result, a result that they did not expect, and they go and immediately challenge that. Um, you know, so it's like students get a certain kind of marks from the professor, and they are happy with that, irrespective of whether they were expecting that or not. A little difficult to understand, but litigants kind of understand this, and they that's why it's important to write a good judgment, so that that is communicated to the litigants by the judicial officers. We also find that, I mean, this is something which is very basic. I'm not going to get into it in detail. The difference between ratio decidendi and obiter dicta, what part of the judgment is integral and is also binding, and that these together make out what is important for the court, for the person who wants to read the judgment and see whether they want to use it, because like I said, these judgments can also serve as precedents going forward. Finally, the language of the court. This is again the same as the language that has been used by the court for conducting the trial. These provisions actually provide for the manner in which the judgment has to be written, the language it has to use, the contents that are important and they need to be there in the particular judgment. I suggest for those of you who are going to be attempting the exam, it's important to be familiar with these provisions specifically. So the basic structural form of the judgment writing would be in this manner, where you would have an introduction setting out the facts, the law and issues, applying both sides of the facts, where you draw some quotes from the cross examination, and also distinguish why you are not. This is, I think, the place for the court to make up its mind when it's applying the law and the facts, to show what was argued. In fact, I think a good judge would take, if they're disagreeing with the defense counsel, take the points made by the defense counsel and try and distinguish them, rather than ignoring them, rather than discarding them. Address them, because you want both parties to be satisfied with the judgment. There is no vendetta, there is no anger or some sort of agenda that these judges have. They are just doing their job, and they're being fair to both parties, which is why it's important that the party which is not going to get a relief from that court must be explain the reasons why they're not getting it. And I think if that explanation happens in this judgment, then that kind of also reduces the kind of litigation that we see these days. Finally, the format. This is just to give you an understanding of how the judgment should appear. A preliminary issue, summary of the prosecution case, summary of the cases of accused persons, the issues, which are basically nothing but the charges that are framed, recording both sides' arguments. Sometimes arguments also bring forth a new point that may not have been taken at the stage of the evidence during the trial, but that's permitted in criminal law. It's again something which is done differently than what we see under CPC. So this is also something which is, I think, a beneficial thing in CRPC because it deals with lives and liberties of people. So which is why there is no bar to take a legal argument which has not been taken earlier during the cross-examination. So these are the other aspects which are to be contained in the judgment. And that's about it. So this brings me to the end of what I wanted to share with you all. I'm sorry for the manner in which we went. It was a little rushed, but I just wanted to conclude giving enough time for some question answers. Though Professor Sandeep Suresh and I had initially planned that we'll allocate about 15 minutes or so for this period, but unfortunately we have less than 5 minutes. So over to the organizers to invite any questions.
Thank you so much, Mr. Benjamin. I'm pretty sure the students have learned a lot. It was a really nice refresher, even for somebody like me who's finished law school a few years ago. So the slides were really well put out, and thank you so much for the slides. We will share it with the students along with the coming brochures, and they can definitely, I hope they can reach out to you just in case they have any clarifications. We have a few questions in the chat box. Shambhavi, do you want to take up a few questions?
Sure. I see a question from Suryansh. The question is for Professor Benjamin. Will there be an adverse inference against the accused if he or she fails to answer the questions under Section 313?
Well, I'll answer that straight away. Actually, there is no adverse inference drawn if they fail to answer a question correctly. So which is why the accused is not administered oath. And so there is no punishment for the accused if there is a case of perjury, which would be if you're answering dishonestly on oath. But more and more what I've seen the Supreme Court do this, and this is again a later development, which I think is good. As I say that as a defense lawyer, it's a good thing because kind of brings some sort of finality to the litigation. The courts expect now that you cannot give a yes and no answer in a 313. So I have seen a lot of these older cases where people would say, I don't know, I can't say. You can't give those kind of answers. You have to give an explanation. If you have been asked a question from the prosecution and you are, you have that material against you, you have to give an explanation. In fact, there's in fact a presumption against an accused drawn in special statutes like Protection of Children from Sexual Offences Act. So which is again, these are cases where the court feels that we need the accused to provide certain information which is within their specific knowledge. So if the accused is not denying their presence in the spot where the offense has been committed, then they have to explain what were they doing there. If they were last seen with the accused person, they have to explain what they were doing, what happened after that. If they were found with the murder weapon or blood-stained clothes, then they have to explain those circumstances. They can't simply say, I can't answer that. I don't know. I can't say, unless they're pleading insanity or loss of memory. I mean, that's a different aspect. Then the trial will come to an end, at least temporarily, under Section 330 and 329 of the CRPC. There's a separate procedure for that. But otherwise, I think accused persons are expected to answer all questions. If they give a wrong answer, then of course they won't be punished for the same. But I have seen that as a defense lawyer, I think it's a great strategy that I use, where I feel that if there is a cross-examination that's happened in a certain manner, then the court would want to see that consistency in the 313. The accused has to try and answer as many questions with all of those things that they want to say to the court, using the manner in which the cross-examination happened. If nothing else, at least the court will see that consistency even at the stage of final argument, that there is a consistency right from the time of the person's arrest in the bail application through the 313. So I think it's a beneficial provision, and the accused should not be fearful of this process.
Thank you, Professor. So we have another question for Professor Sandeep. So I think the question is from Kushi, and she says, Professor, you said that the magistrate is entrusted with the responsibility to not prolong the police custody for unnecessarily. Similarly, what are the checks and balances for ensuring that the judicial custody is not prolonged beyond a prescribed time?
Right. Thank you so much, Ashwati, and thank you, Kushi, for the question. Something that I forgot to specify during my talk was that yes, there is one way in which police custody is curtailed and given not blanketly, but given in a piecemeal way, depending on a time-to-time check. However, the statute lays down a specific limitation for police custody, which is important to understand the limitation on judicial custody. Only for the first 15 days from the day of first remand can you give police custody to the police, right, of an individual. After that, till the 60th day or till the 90th day, as the case may be, it can only be judicial custody. So while there are statutory prescriptions which enable the magistrates to sort of ensure that police custody is not arbitrarily claimed by the police and it's not given as easy as the police might think, but for judicial custody to be sort of how to sort of stop its prolongation beyond the point of time without any reasonable cause, there is not much statutory step beyond saying that okay, on the 60th day that the police must file the charge sheet. If on the 60th day the police has not filed the charge sheet, then the magistrate ought to give the bail. But there are a few problems there. As I said, you or your lawyer has to, through your lawyer, you have to file that application for bail on the 61st day in the morning. I think Professor Simon will probably agree that there are lawyers who will send their clerks with the application right in the morning itself to get the first thing done in the morning to get the application done before the police comes with their charge sheet, right? So it's a matter of race there. Now, because of lack of legal aid, because of quality legal aid, many people lose this right. Now, what happens is there is case law which says that even after the 60th day, let's assume, let's say on the 62nd day, the police comes and files a charge sheet. And before that, you have not filed an application for this 167 bail. Unfortunately, again, that gets extinguished, right? Which is where I, in the beginning, said that magistrates ought to ensure that there is a check on the records of the case. Again, you can't expect the magistrates to be fully aware of every case under their belt, right? They have plenty of cases under their belt, which is where lawyers become important, which is where lawyers become the reminder bells for all these instances. So that's the practical way of sort of dealing with it. There is also one more point that you need to keep in mind, that there have been several cases in the past where magistrates have, like for example, okay, 60th day, 60th day is complete, police has not filed the charge sheet. 61st day, the accused, the arrested person goes and files his application for default bail. Magistrate grants it. There have been instances where, let's say on the 70th day from there, the police comes and now files a charge sheet, right? What the magistrates have done is wrongly is that they've said, okay, now that the police has filed a charge sheet, now your bail is cancelled, you go back to the jail. Now that's unreasonable, that's not permitted by the law, right? Once you have been given bail by any means, by any reasons, the only process for cancellation is given in section 439, 437 of the CRPC. Without that, just by the police filing a charge sheet, your judicial remand or judicial custody remand cannot be again restarted. That's unreasonable. So in the past, wherever the magistrates have done it, the Supreme Court in appeal or high courts in appeal have sort of condemned that process, and they have said that mere filing of the charge sheet after the default bail is granted cannot mean that the judicial remand can again be extended and this person can be rearrested and put back in. So there are a few rules like that. But I believe more importantly, to ensure that judicial custody doesn't go beyond a point, is that legal aid should be to the point. Yeah, I hope that helps.
Thank you, Professor. So Nandini has a question, and in fact, I had a very similar question for Mr. Benjamin. So the question is, can the accused refuse to answer questions under Article 23 of in the Indian Constitution?
Yes. So this provision is in consonance with Article 20, subclause 3, and there is no dispute regarding that. But of course, the court is free to, because by that time this is a trial. This is not a case where a person is being interrogated and they're being subjected to any kind of pressure for them to give that answer which is going to be used against them, or give any information that's going to be used against them. It's like I said, it's a beneficial provision. So if the accused does not want to take the benefit of that opportunity and does not want to answer a question correctly, then they won't be punished for it. It's not that the court is going to punish someone for giving a false answer under 313. And that's why the provision of 313 is in consonance with Article 20, subclause 3. The debate, of course, would be in other forms of interrogation, where we now find more and more with technology coming in, the lie detector test, the narco analysis, where consent has to be taken from the accused person for them to be subjected to this process. But when they are in that process, they are not fully conscious or aware of what is being asked and what are they answering. And then that this is a gray area as far as that does that consent protect the investigating agencies to take it. In fact, the investigating agencies have more and more been putting pressure that they want that consent to be done away with, so that they are able to, in fact, there's a lot of safeguard to say that the consent must be properly given, has to be recorded, and then there are some safeguards in the manner in which this process has to be, conducted. There are also instances where accused persons can come back and retract that statement that has been recorded. But none of those fears are there as far as 313 is concerned. And so this is just to answer that question. I hope that's fine. But I want to also take this chance to add to what Professor Sandeep Suresh was saying about the uh, process of compulsory bail. So this actually, having been in that position where I have my client has been given bail under 167 too, and there have been times that we have not been given that opportunity to be released on bail, though that period has been over. The law is actually, a, a little bit confusing here, because there are judgments which say one thing over the other. But what I have been able to understand is that this, though it says that it's a matter of right, the bail at that stage is a matter of right. I don't think the courts look at it like that, or the law has been created to be like that. It's actually in favor of the investigating agency. So it's not like if they have failed to file something on the 60th day that a person is entitled to bail automatically. Accused has to still apply for bail. But what happens when, when the before the application of the accused comes in, the charge sheet has been received, the police report has been received. More often than not, the courts deny the bail. And why? Because it's not like you have a ticket, so you now have to be released from jail. That 60th day or 90th day doesn't guarantee a person release. It is basically, they're looking at the larger scheme of things, and the larger scheme of things, if the investigating agency has not been able to complete its investigation within that period, then they say that of course the benefit must accrue to the accused person, provided that person is in a position to provide sureties, which is why that legal aid angle comes in, when you have to see whether an accused person can provide sureties, etc. But if an accused person, if the investigating agency, like one of those students who are making this last minute submission, they want that extension, deadline has to be extended, they are doing that work. You can penalize them, you can obviously tell the court can make some remarks that this is not expected or whatever, but it will have to accept it. It cannot then take a view that bail has to be granted, though charge sheet is being filed at that stage. And so the larger view is that the investigating agency will have to be given that benefit of, because they brought in that charge sheet on the 60th day, at the end of the 60th day, before the bail application has come in. If both those things are before the court will accept the charge sheet and tell the accused person, I'm sorry, though there are judgments which will say this is a matter of right, but that's not happening here. So practically, this is what happens in courts, and which is why I think when as law students, you think of something, because you're reading these judgments and you're going there and you're arguing with the judge that, look, the 60th day has happened today, and I have filed my bail application, like Professor Sandeep Suresh was saying, like I filed it early in the morning, even before the court has opened. The person is there with the bail application, but the court will say, wait, we're not going to dispose of this bail application right now. We'll wait till 4 p.m. And till 4 p.m., if the police comes in with the charge sheet, then no bail is going to be given.
Yes. So whatever your right only arises on the 61st or the 91st day.
Yeah, that's correct.
So would it be right in saying that there is definitely a gray area to sort of say that there is a slight gap between what's written in black and white and what actually happens, or
I mean, I don't think CRPC also talks about this. They just say that, okay, 60 days, 90 days. They don't say anything beyond that. So there is nothing written also as such. But yes, definitely there is a lot of gray spaces as far as this area is concerned, which is where, as Simon said, we will have to sort of be practically at the notch to sort of deal with these situations.
okay.
Also, one more point, if I can add to that, just as a reference, the case about or in and around Ajmal Amir Kasab, right, where the Supreme Court passed a judgment, that's quite useful to understanding the right against self-incrimination angle and the right to remain silent angle with respect to police and that.
There is one more question for Professor Benjamin. So Nandini is saying that you spoke about similar processes which takes place in the United States. What is the status of a plea bargaining in India? As far as I've understood, it's a gray area, so the accused can get an appropriate plea deal. Can the accused get an appropriate plea deal?
I think we have a very well-defined plea bargaining system which is existing in India. The law recognizes this process. It's certain offences have been left out. Heinous offences, you cannot do plea bargaining in them. But of course, in all the other offences which are recognized under this process, the procedure has been very clearly provided that accused persons will then make that application, because the court understands that at this stage you're putting in your defenses, you're laying down your defenses, and you're admitting to your role. And the court will also look at the position of that applicant, the accused person, their age, the fact that they may be a student, they may be a young professional, a woman. What are the circumstances in which that offense was committed? In fact, I was just discussing this with somebody the other day about a magistrate in Delhi writing a poem about a tea seller, who was brought in for a trial because he was on the wrong side of the law, and so obviously the law required that he be punished for the offense that he's committed. This was a railway magistrate, so the tea seller was there as an accused, and the magistrate was forced to see that this is actually the circumstance of a failure on the part of a welfare state program. Like, the person is trying to earn a fair living by providing some service and charging a very reasonable sum of money for that. But obviously, the law looks at him in a very different way. This has also been so. This magistrate then went on to resign from his post in that same year, after having served for 3 years. He's now a practicing advocate, Mr. Bharat Chugh, very good lawyer and a good jurist as well. And this particular judgment that was written about that incident also featured in the Delhi High Court decision rendered by Justice Muralidhar, where this poem was spoken about, and it's a beautiful understanding of the society that we live in. Like, not all crimes are committed with a sense of doing some wrong. There could be some aspects of that crime which could be because a resultant of a person being pushed in that direction, and there are circumstances. You also look at the individual's whole life, how it was till that point, and what is going to happen if they're being convicted. And which is why I think it's a very good addition to our system, that plea bargaining thing which we have. There's no gray area as far as that is concerned. Of course, the gray area would be if somebody wants to include certain other offenses, but I think rightly some offenses have been left out, the heinous offenses, because I think then there is a great chance of its misuse.
Thank you so much. I don't think there are any more questions on the chat box, but I think we'll wait for about 30 seconds to see if anybody wants to unmute and perhaps have a discussion on anything that's been discussed.
I'll take this opportunity to thank the organizers also for this. It was a lovely opportunity. It's a great concept. Thank you for having both me and Professor Suresh. Like we teach this subject, but it was difficult to try and put in all of this in a small capsule. I can see in the audience there are some of our former students also, so it's nice to speak to an audience which is already so familiar with the process. So I hope it's been enjoyable for them.
Yeah, same from my side. It's been good to sort of get back to the mode of thinking about the procedure. Considering that I won't be teaching criminal procedure next semester for certain reasons. So yeah, thanks for giving me this opportunity, and thank Shambhavi specifically for persuading me to sort of come for the session. So, and thank you so much, Simon.
Thank you, professors, for coming. Sorry, Ashwati, please go ahead.
No, please go ahead.
No, that's fine. That's fine. Go ahead.
Okay, so I think that brings us to the end of today's session. I'd again take the opportunity to thank both Professor Suresh as well as Professor Benjamin for very kindly accepting our invitation to be part of our judicial examination lecture series, the first phase. I would also like to extend my thanks to my colleagues, Ms. Trupti Panigrahi, Professor Mukesh Arora, Ms. Pratibha Tandon, and lastly, Ms. Shambhavi Shivani, who has been a very good co-host for today's session. We have been working very hard trying to get people on board to sort of understand what the judicial examination requires and then rendering those kind of lectures to the students. I will not be able to thank the graphics and design team enough because we've been pestering them time and again for the flyers and the brochures, but they've been kind enough to work in coordination with us. And lastly, I would also like to thank the students without whom the first phase of the judicial examination lecture series wouldn't have been a success. Over to you, Shambhavi.
Yeah. So, students, we have come here. We have come to the conclusion of phase 1, and we will be back with phase 2 on the 25th of September 2021, which is Saturday. Same time, that is 12 to 1 p.m. And the subject would be, the lecture would be on the Indian Penal Code 1860, and it will be delivered by Advocate Amit Anand Tiwari, who is presently the Additional Advocate General for State of Tamil Nadu at the Honorable Supreme Court of India. So see you on 25th, and wish you all the very best. And I think there's a question from Advait, that do we have recordings for the previous lectures? Yes, we do. And we will be shortly uploading all the recordings of the lectures on YouTube, and the link will be circulated. Thank you. Thank you, professors, once again. Thank you, Ashwati.
Hey, everyone.
Thank you so much. Thank you.
Also, I would like to sort of tell everybody at the final count that, I don't know how much we helped in terms of exams, but, let's not always romanticize Supreme Court judges or High Court judges. There is a lot of merit to be devoted to the district judiciary, which is, according to me, very wrongly referred to always as lower courts or subordinate courts, but they are the pillars of the foundation. So would like to see, future judicial officers from this cohort. All the best.